litigated the issue again, put him through a jury trial and everything. Well, there's no way this thing's going to stand up in the appellate court. The judge we've got on this particular case got a substance abuse problem and has a goofy view of how the legal system is supposed to work. This is the same judge I was referring to earlier. We gave him such fits on another criminal case the same individual had that when it came time to litigate this one, he just said, I've had enough, I'm out of here, let another judge handle this one. And there's no possible way that this guy is going to do any amount of time on this failure to appear because the issue has already been litigated. Collateral estoppel applies both in civil cases and in criminal cases. There's a 1970 Supreme Court case called Ash versus Swenson that you'll see this in from 25 years ago. It was a robbery in which a guy came in and he was acquitted of robbing one person in this poker game, and so the prosecutor came back and charged him for robbing another person in the poker game, and the Supreme Court says, oh, wait a minute here, you cannot litigate because it was state of Missouri versus Mr. Ash. I believe that's the fellow I'm looking for. It was either Ash or Swenson. It can only be one of two. And anyway, they said, no, the state of Missouri has already litigated this set of facts against this individual. Forget it. Not going to happen. Peter?
In a nice stopping point. In a nice stopping point right here. I think with the power outage, we failed to go over relief requested and the verification statement.
Okay.
So if we can just do that real fast.
Sure. Okay. Yeah, he's right there with the power outage. What you have to do is now, once you've bolted up your legal claims, in other words, you've said, okay, this guy, and what I do, no attorney that I know of does this. I learned this trick from the same man who's been flaming Internal Revenue Service criminal cases for years and done a couple other things. What he taught me is if you put a motion or a complaint before a federal district court, if you plug in the case law, you plug in the statutes, you plug in the Constitution, what you can do is if it's done right, and see that's what was done on this particular piece of work here that I did for Peter a few years back that you have as part of your course materials. If you look at the way I did the legal claims, most attorneys, they'll put under legal claims, they'll simply put this, 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 and this, and they won't elaborate. Well, what I do is I plug in the case law, the statutes. I mean, I hit them with everything but the kitchen sink. Because if you do that, when you get the usual toss out on your ear routine, I got to warn you, federal district court, your odds of succeeding, even if you're 100% right at the district level, are only 1 in 3, because they look at you, oh, here comes a pro se litigant, a species of life somewhat lower than the cockroach. So they throw you out figuring you will not know what to do next. But if you plug in all the case law, when it gets to the next higher level, and I'm going to show you how to do that. We're going to go through the courtroom walls here directly after relief requested. If you do that, what will quite often happen is the people in the appellate court will look at it and say, this judge already had all the case law in front of him. What is this thing doing up here? That's why you'll see in this one here, you'll see the words summary reversal. In other words, the 8th Circuit Court of Appeals said, this thing doesn't belong up here. This guy knew what the law was in this circuit. Send it back down. If you do that, all you have to do, the other advantage you have is that if it's done right, when you get ready to do your appeal brief, all you have to do is like the table of contents, statutes and authorities and so forth. I'm going to show you how to do that. All you have to do is change the first and last pages of your complaint. You change the caption, you change the relief requested, and you take everything that you had as far as the case law, the statutes, your constitutional arguments, and since they didn't pay any attention to them at the lower court level, now you've got them into the appellate court, and the amount of work you had to do was minimal. Now, the last thing you're going to ask for here after legal claims, once you have, as Peter says, carriage bolted the legal claims to your facts, they have got to coincide. And if you really need to see how this is done, I'll tell you the easiest way to do it. I learned this about 20 years ago. I had a case where a guy came to me and he wanted to get out of federal prison. And he'd been there for about 7 years and he had about 13 to go. And he came to me and says, Brown, I want you to help me. I says, man, I'm afraid I'll hurt you. And he says, Brown, you can't hurt me. He says, I'm going to do another 13 years. He said, nobody else is going to help me. I said, okay, fine. So I looked at his case. I said, this looks like a case that's out of the Seventh Circuit called Garofalo versus Benson. So what I did was, and you can do the same, when you find a case that looks exactly like yours, and occasionally you'll find something close enough, what I did was I simply called the court clerk and I said, I want to buy a complete record of this case. So she said, okay, fine. Well, the first thing, when I got all the pleadings in, I saw the issues Garofalo raised, I saw the responses the U.S. Attorney raised, I saw his answer to the United States Attorney, I saw the judge's ruling. In other words, I had it all laid out, connect the dots, and I thought, the only thing I noticed is, man, this guy Garofalo, he can't spell. I mean, this is awful. So what I did was I copied what he did word for word, and then went in front of a federal judge named S.U. Dillon, who was the same one who had turned Garofalo loose on exactly the same issue, only he ruled against me. And I'm looking at this thinking, geez, you know, apparently the law means something different this year than it did last year. So I showed it to a fellow named Mayberry, who's won a couple of Supreme Court cases. And Mayberry says, Brown, he says, the Seventh Circuit will reverse this. So I filed a notice of appeal, and I won it in the Seventh Circuit. You'll find the case citation right there in my Brown's Lawsuit Cookbook. The citation, I believe, is from 1977. It's Cox versus Benson. Anyway, if you simply order the pleadings, you'll be amazed at what you can find out. And you can see exactly how the guy before you did it and see if it's anything close. Now, what we're going to do now is once you have filed this thing, all right, what you've done is you've got the complaint, civil cover sheet, you got a docket number, you've paid your $120 to the federal court downtown, you've got your summons form, it's filled out, you see how to do it in the book there, summons form and complaint, you find a process server. You can look under attorney services, you can look under process servers. Peter?
Relief requested and verification.
I'm going to get to that, yeah. I've got, in fact, I don't know why I keep erasing this. Relief requested, and then verification, which so this thing here you don't really need. I'll come back to that. But what you do is, once you have filed this thing, is it starts, and let me back up here on relief requested. You've got to tell the judge what it is you want. Now, I knew a guy once that he never won a case. He couldn't figure out why he was throwing all this stuff into federal court, and he was always losing it. Well, the reason was he would put the caption down, statement of the case, jurisdiction, facts, legal claims. The only thing is he never once told the federal judge what he wanted. In other words, you've got to tell him what you want. Do you want trial by jury? Do you want compensatory damages, which means to compensate you for the injury? Do you want punitive damages, which means to punish the other party for their egregious behavior? Do you want permission for leave to amend? Do you want an injunction? In other words, you've got to be able to spell out specifically what it is you want. And once you've done that, and then you have what's called a signature block, you sign your name down here, you have a verification, which in a lot of areas is just simply not necessary. Now with states, you've got to be careful because a lot of states will have all kinds of goofy requirements, like you've got to have a verification or a notary public or whatever. But in the federal courts, they basically just take it the way you want to submit it. And you've got to be careful in federal courts because if you start filling up the courts with a bunch of lies, they have federal statutes they can come back on you on. Now, are there any questions so far on how to draft a complaint and get it served before we go into what to do next? Any questions? I need you to come up to one of the microphones, gentlemen. Okay, you go.
Okay, I've got a question. I have a case, company in California, and I just know a couple of the principals, and I don't know, there's probably 12 or 15 people that are also involved, and I don't know who they are.
Okay, what you do in a case like that on the caption, you know who one of them is? You got even a single name?
Oh, yes.
Okay, then what
I've got
you
a
do
couple
is,
of names.
All right, then you put the two names, and then you put those 1 through 20 who will be, in other words, you're going to come back and amend the complaint and add their names when you find out what they are, which is what you get under discovery, which I'll show you. Next, then I'll get to you in a second, Al.
Yeah, quick scenario. File the complaint, 42 complaint, within the 120-day period, learned of some names, added those names, and then served the amended complaint, the original never being served.
Okay, yeah, you can do that. Not a problem. Okay, Al?
You might get to this later on, I'm not sure, but the standard, I understand, reason for dismissal is failure to state a claim for which relief can be granted. Can you explain that for us?
Yeah, okay. Now, what that is, that goes two ways. That's Federal Rule of Civil Procedure 12, I believe it's B1, failure to state a claim upon which relief can be granted. If you'd sued somebody because his dog was ugly, all right, that's failure to state a claim. Now, almost all attorneys, all prosecutors will use that. It's a boilerplate defense, and all you have to do is say, hey, I do have a claim, all right, and the easiest way to do it is say, not only do I have a claim, but my claim is identical to this dude over here, and here's the case citation. Ma'am, on you.
I think the reason they do that is that they must say that, you know, first time out, or they waive that right to ever do anything like that.
No, because on a complaint that actually does not state a claim, the judge himself can toss it anytime he feels like it. They do have what are called boilerplate defenses. In many cases, that's one of them. Then they have affirmative defenses. I mean, I have seen some real garbage done by attorneys in which they come with all these failure to state a claim nonsense, and then they have all these affirmative defenses, and a lot of times you read what they're writing and say, wait a minute, this is from his last case, this doesn't even apply to me. For example, we had a case, Peter and I had a case down in Missouri for a couple of girls down there in the Clay County Jail, and they gave us some boilerplate defenses saying that, you know, we can't get money damages from these people. Well, it was a little strange because we never asked for money damages. In other words, what she had done was she had simply cobbled together a boilerplate set of answers and affirmative defenses, about half of which did not even apply to the case we were litigating. They do that a lot.
I was going to make a comment on that.
Sure.
Summons. Here in the Northern District of Texas, they don't require us to list all the people on that summons. We can just put the first name et al. And send one out to each person, you know, putting a different name on each one.
Well, that's true everywhere. You do not have to list every, because, I mean, obviously, if you've got 40 plaintiffs, it won't fit. No, it's et al. The summons simply tells the court that, A, the guy has been tagged in which case it is, all right?
Right.
But I got to warn you, now, there is a provision where under Rule 4 of the Federal Rules of Civil Procedure governing service of process, where you can mail a complaint and a summons to someone and send them a stamped self-addressed envelope and they're supposed to mail it back. Don't even think about it. And don't think about going in form of pauperous, because if there's some way the opposing side can screw it up, they will. In other words, you don't take any chances. I've seen some awful good cases lost like that.
Okay, that's good to know. I didn't know that because I know we have mailed some in the past, or we have done personal service by a disinterested party. And also, I thought I'd comment, if one goes as a pauper, then the U.S. Marshal will do the service for them.
Well, here's your problem. Let me tell you what's wrong with going in form of pauperous. It's this. I haven't allowed anybody that I've worked for 20 years to do that. I had a guy once in Terre Haute Federal Prison. I had a federal judge. I mean, I had him mousetrapped. Either way he went, I was going to destroy him. Here's what's wrong with in form of pauperous. Here's what you're going to run into. If you pay for it, they have to litigate it. But in form of pauperous, you're going to run head-on into this statute here that's an absolute killer. It's Title 28, Section United States Code, Section 1915D. And what it means is that if a federal judge looks at your complaint and in his mind it's frivolous, he can toss you out on your keister. It also means that if you appeal in form of pauperous, same problem. If you appeal and you're paying for it, you're not going to run into this. In other words, what you're going to do is you're going to take all your time and effort and everything else, and you're going to flush it down the toilet because you didn't want to pay $120 for the service of process, maybe $30 for a defendant to tag these defendants with, and $105 to file your notice of appeal. It's not worth it, people. I mean, what you'll wind up with is you'll find that when you get tossed for this reason, you say, wait a minute, I don't think this is frivolous, but they're going to waste you. Al?
Are you saying that that's the only time they file for frivolous is under pauper? I don't think that's what you're saying, but I just want to make sure.
You're correct. No, that's not the only time, but what this does is this gives them a license to dismiss for being frivolous that they don't normally have. I mean, normally they're supposed to give you a chance to clean it up, to file an amended complaint, to do all sorts of things that in form of pauperous, if you go to where you're not paying the filing fees, they literally have an excuse to say this thing is frivolous. It's just like this guy that I did this piece of work for 20 years ago. I mean, I had this federal judge where no matter which way he went, and I told him, and like I've been telling everybody for over 21 years, you don't file anything in form of pauperous. He talked to some other guy who'd been 3 years at Marquette Law School. This other guy says, oh, you can do it in form of pauperous. And of course, he got tossed out for being frivolous just when I was about to completely destroy a federal judge. You think I wasn't an unhappy camper? Yes, sir.
Does that work in state cases also?
Yes, it does. However, you won't have the same statute number. In other words, the state will have a different set of provisions for going in form of pauperous. This is strictly a federal statute. Now, what we're going to do now is... Sure, yeah. Robert?
I might add that with regards to the form of pauperous issue, that Article 4 of the Articles of Confederation provide that paupers have no rights, none.
Oh, well, okay. Isn't that what I've been trying to tell everybody? You don't have any rights when you pay for the damn thing, you know? Let alone when you try to do it this way. Okay, now what we're going to do is I'm going to run you through, as we've been saying, the courtroom waltz, okay? Here's what's going to happen. Oh, the question.
What about the ineffectual assistance of counsel?
Okay, ineffective assistance of counsel, that would only apply in a criminal case. It does not apply in a civil case. Let me warn you, there is case law on this. You can never, ever get another hearing in any court, federal or state, because your attorney was a moron. In other words, you hired him, you had to live with him, and they'll tell you quite plainly in the case law is that if an attorney botches up your case in a civil case, there is no such thing as ineffective assistance of counsel in a civil case. You hired this idiot, you got to live with him. The only thing you can do is sue him for legal malpractice, and even then you've got to get in within the statute of limitations. Now, in a criminal case on ineffective assistance of counsel, that comes under the Sixth Amendment, and unfortunately, since the United States Supreme Court decision in Strickland versus Washington in 1985, in a criminal case, it really doesn't make any difference if your attorney was falling down drunk. It really doesn't make any difference how bad he was. The odds are that the courts are going to say, well, he was adequate. Well, the fact is, if they were completely truthful, almost all attorneys are ineffective. All right, now, let's get back here to, we're going to show you what happens next. Now, once you have filed a complaint, and once you have tagged the opposing party, one of two things is going to happen. He is either going to answer, or he is not going to answer. And if he doesn't answer, that's the easiest. That's where we've got Janet Reno here. She didn't answer. And if they don't answer, you normally go for what is called a default. In the federal courts, that would be Federal Rule of Civil Procedure 55. Now, I got to warn you, is that if you're litigating against the federal government, defaults do not apply. You have to use Rule 56. That's a motion for summary judgment. It can be used for the same thing. That's what we did on Janet Reno here. If they don't respond, this is obviously the easiest. You go in for either a default judgment, you go in for a summary judgment. If they have not contested your pleadings, then the case is yours. Now all you have to do is collect, which is not part of this program right now, because I don't believe a whole lot of you have ever litigated a case all the way through federal court or through state court, so I'm not going to get into collecting judgments that you're not even going to see for a year and a half. I got to warn you that almost any case takes anywhere from 6 months to 3 years to adjudicate. None of it happens easily or quickly. All right, we have just disposed with default or summary judgment. Default in the case of a civilian, summary judgment in the case of the federal government. You will find Texas rules of civil procedure that very closely parallel these. And what you have to study, remember the procedure? I'll give you an analogy. The statutes, the law, those are the equivalent of chess pieces. The procedure is how you move them. And if you learn the procedure, you'd be amazed at what you can do with the law. Now, what normally is going to happen, most people do not fall asleep at the switch like the Attorney General of the United States. Most people are going to fight back. In other words, they're going to file an answer. And the answer is normally going to be composed of two sections. One is going to be all the answers like failure to state a claim, all this kind of business, all right? Or they're going to argue that there are facts in dispute. Well, if there are facts in dispute, that's what juries are for. All you have to do is remind the court of that, which I'll show you how to do in a minute. And then they will have what are called affirmative defenses. Like, for example, the plaintiff contributed to his own problem. In other words, you know, the plaintiff stood in front of a steamroller that he wasn't even aware was there. He was on his own property, and this guy on the steamroller was drunk and ran over him and flattened him out like a pancake, and he contributed because of his own negligence. I mean, you will actually get that kind of garbage in some of these answers. Now, once the other side has answered you, all right, then you can come back, and I would suggest you do this very strongly, and you point out where everything that the other side has said is crap. And once you have set that, now in the federal courts now, they've got a rule they just introduced a couple of years ago. It's this one here. Fortunately, in a lot of localities, it does not apply to pro se litigants, but 26D mandates that before you can start what's known as discovery, you have to meet and confer. You've got to sit down with the other side, and you've got to have some meeting. Now, what the purpose of this is, I don't know. But, and I kind of wonder if Congress, when they enacted it, knew either. But after this happens, and again, you'll have to get what's called the local rules of court. Let me caution you on this, too. In addition to the federal rules of civil procedure, the federal courts are supposed to be uniform, but almost every local court will have their own set of rules. All you have to do is you call up the court clerk and say, have you got a set of local rules? And she'll send them to you. And when you read the rules, you're going to see what the federal rules of civil procedure left out. So now that you've got the local court rules and you've got these rules here, you can read anything and hopefully understand anything that any attorney can do. In other words, you'll be able to run this thing through the courtroom walls. Now, once the issues have been set and you have survived the first motion to dismiss or motion for judgment on the pleadings or motion for summary judgment or whatever it is, you can then go into discovery. Now, I've got to caution you on one thing here, that if you happen to be a defendant in a case, there's one rule here that you can really get mousetrapped on in federal court if you're not careful, you know, which is kind of neat. I like it because I use this against federal employees all the time. It's Federal Rule of Civil Procedure 8D, and what it does is any statement not controverted, as in your responsive pleadings, must be accepted as true. In other words, if I make 5 statements like your dog is ugly, your house is falling down, and you controvert, in other words, you answer 4 of those statements, say, no, that's not true, but you leave one of those statements unanswered, like, for example, you've been throwing the rattlesnakes over into my yard, and you don't answer that, you don't address it in any way, shape, or form, it now must be accepted as true by the court, even if it's made out of whole cloth. So be careful. You've got to study these rules. My recommendation is when you bolt up a complaint and you're ready to go to federal court and you think you're ready to rock and roll, take a day or 3 out, study these rules, both the federal rules of civil procedure. There are approximately 84 of them, and they've got subsections like this 8D. They got a bunch of other stuff in there too. Obviously, they've got A through C, and I think there's an E in there too. Study these rules, both the rules from the local court and the rules of civil procedure, state of Texas, obviously, Texas rules of civil procedure, whatever local court rules they have, and they almost always have. I mean, you can go to the most backward section of Missouri, and a local court out there in the weeds, they've got their own set of rules that the local judges put together that don't match up with the rules anywhere else. Now, once you have gotten past the initial hurdle, your case is still on track, it hasn't been dismissed, and remember, if it does get dismissed, you file what's called a notice of appeal. There is a form there in your lawsuit cookbook. It shows you how to do it in federal court. You just file an original and 1 copy with the court. You send 1 copy to the opposition. If you sue somebody and their attorney comes in on the case from then on, you no longer send them what you're doing with a certificate of service. Incidentally, all these documents after the initial complaint, you have to have what's called a certificate of service so the court can see that you actually did mail it to the opposing party. Now, let me caution you on something else here. This is a favorite lawyer trick that I've run into. In fact, it was taught to me by United States attorneys. And what they do is this. A lot of these attorneys, they say, pro se litigant does not know what is happening. So what they do is they put a certificate of service that they mailed you their motion to dismiss on such and such a date, but they just don't bother to mail you a copy. They just mail it to the court with this bogus certificate of service. So all of a sudden, you're sitting there, and you just got your case tossed out of court because you didn't even know there was a hearing. I had a case like this in California years ago, and this attorney really thought he was slick. And the guy he was working for also thought he was slick. And the people I was working for, I said, look, I can tell by looking at this attorney that he's a bigger dirtbag than most of them. So here's what he's going to do. He is going to put in all these motions, and he's not going to send us a copy, so that what he's going to hope for is he's going to get this case thrown out of court because we don't know what time it is. So every Friday, I simply went up to the clerk's office, said, let me see the file, gave her the docket number. She brought the file out and looked at it and said, oh, okay, this idiot filed this 3 days ago. I said, Xerox this for me. He was getting all these answers to all these motions that he knew he'd never mailed to us. And he did this about 6 times, and I think it finally penetrated that we weren't as dumb as he thought we were. Now, once you've got this, you'll also, a lot of times, you'll find a set of instructions that they'll have what's called a scheduling order. And that's governed by this statute here. It's Title 28, United States Code, and it's Section 471 et sequitur. And what this statute mandates is that every federal court maintain a program for keeping stuff on track and getting it litigated. In other words, what this statute mandates is that all litigation is supposed to be just, speedy, and inexpensive. Unfortunately, you run into judicial doctrines, which we'll probably discuss some tomorrow, that they don't pay any attention to this stuff Congress enacts. This is a suggestion. It's not a law. I mean, it's only a law if the Supreme Court says it is. Congress says it is. It's a suggestion. But you'll quite often get what's called a scheduling order, and they'll want to look at it and say, okay, what time can we have discovery completed? When can we have this thing ready to trial? The idea is to get everything in front of a jury within 18 months. Unfortunately, it does not work like that because, again, you've got federal judges who are not even remotely concerned with upholding their oath of office 9 times out of 10. Ma'am?
Do you do a certificate of conference on your motions?
What is a certificate of conference?
Well, you have to call the other side. At least they do in the Northern District here. We have to call the other side.
That would be on your, see, again, that's a local rule that I'm not familiar with, but if that's what you're supposed to do, then that would more than likely only apply for the scheduling conference. In other words, when you're actually supposed to start walking this thing through.
No, on all our motions, we have to do a certificate of conference. We have to call the other side and see if they have any objections to the motion.
Okay, now you're talking about for federal court?
Mm-hmm. And state court, too.
Okay, do you have a copy of the local rule for that?
I have the local rules at home. I'll see if it's in there.
Yeah, bring the local rule, because if there is no such animal in the local rules, they can't enforce it. If there is, then yeah, you have to live with it. But I would like to see it in print so I could see exactly what it says.
Well, we can go down the road 60 miles to the next federal court, and they do not require it.
That's what I said. Every federal court is different. Every county court is different. Every state court is different. What you're dealing with in the United States, to a large extent, is legal anarchy. Fortunately, they reduce most of it to print, so once you learn how to operate in a certain court, you can operate in that court. That does not mean you're going to be able to do the same thing in the next court. You've got to learn the rules all over again. Now, once you have gone through the basics and your case has survived your basic motion to dismiss, you're going to start what's known as discovery. And the way to do this is they're going to limit you in most federal jurisdictions and in most state jurisdictions to X number of questions you can ask. Now, interrogatories come in 4 flavors. You have depositions. In other words, you sit the person down, you ask them questions. You have interrogatories. Now, depositions are expensive. You got to have a court reporter and all kinds of stuff. And I never use them unless I'm trying to ambush somebody, because interrogatories are 100 times cheaper. Interrogatories, requests for admissions, requests for production of documents. Now, in interrogatories, the way that you need to do it, see, most attorneys, what they'll do is when they know they've got 25 interrogatories and that's what they're allowed, they'll ask all 25 of them, and they've hit their limit, and then they have to get permission from the court to ask the next single interrogatory. What I normally do is this. If I've got a case I'm working on, I will not ask, and I know I've got 25 interrogatories, I won't ask 25. I'll ask 5, because every one of those 5 has got a trap set in it. In other words, if the guy answers yes, I have 2 more interrogatories I can ask him here. If he answers no, maybe I have another one I can ask here. Let's say that he answers no, all right, to this interrogatory, or request for admission. Well, when he answers this question no, that leads me to 2 more questions here. And what you'll find is, about the 3rd set of interrogatories down, when you're down to about number 15, you've got the guy squealing, because what you're doing, because he knows as you keep tightening the noose on him, what is winding up happening is this is.
I don't have any credits. I don't get any credit, and I don't give anybody any credit. The views expressed and or implied on this program may not be that of the station. Well, I'm sure that's true. I'm sure the station isn't going to endorse my concepts that judges are no good, courts are no good, lawyers are no good, cable TV operators are no good. The police don't do their job, and they're mean to people, and they arrest people whom they don't have any statutory authority to arrest. The rest is it okay. I give her plenty of time for a new program to be ready. And I send her boxes and stamps, I think. But now, I don't think I can do this, Patrice, because Cablevision and Charles Dolan stole my editing capacity. You remember the Lindbrook ripoff? The Lindbrook thievery of Charles Dolan, along with stealing my shares, and along with stealing Yonkers from me, New Rochelle, Harrison, Portchester, Yorktown. How am I going to handle this, folks? I think it's editorial control anyhow, which is strictly against the law of federal, municipal, and state. Let me make up one, and then figure out how I can put it. If you're making 35 programs, or that is 35, if you're supplying 35 cable TV operators, you can't stop for each one the way I have to for Albany, and put up a tag on these arbitrary rules. There's no legal basis for these things, no factual basis. I don't think they can make us do it. What do you think, folks? I think the grammar's wrong. May not be those of this station. The grammar expressed on this station may not be that of Glendora. Folks, do you agree with me on this? It doesn't do the station any good for me to disclaim it. I can't say the station disclaims it. If the station wants to disclaim it, the station has to say so itself, doesn't it? I can't say it for them. I don't think it would have any effect in court. Glendora said that the station disclaims these views. What good does that do the station? The station itself has to take the responsibility and accountability and say, we the station disclaim it. Don't you think? So I write this out to them and I say, I don't think that my saying you disclaim it will protect you in court. You yourself have to do the disclaiming. And then I point out that further, it's a hardship on me. It limits and prohibits me strictly against New York State law, Public Service Law, Section 229. I send tapes to 35 cable TV stations, and I can't make a special edition for each station. And and this is a third point, none of the other 35 TV stations requires this. Only you do. So I think you'd better revisit this and get back to me. Okay, Patrice? Other people have email. I have public access. That's how I communicate with people. This is a letter of thanks to Franklin for sending the American Red Cross $4. So we hear from them, we'll just send them a $4 again. And change the mailing address for the time being. Box 416, White Plains, New York is the permanent address. And we're up here in the woods for the time being. Hopewell Junction, Box 69, 12533. But if we take the 1980 off of the road, why should we pay insurance on it? Whole thing is a racket. The way the insurance companies lobbied the state legislature and forced this onto the people. Nothing but greed. And we get the injury. Expenses into the book. Last Wednesday's expenses. Yesterday's expenses. This is the business out. And the personal out. We entered the money spent and the money in for the first week of October. Or was it the second week? Second week of October. And we added up how much money was spent on business and how much was spent on personal. And we enter each item into the column for the end of the month. Postage, car repair, groceries, printing, donations receipted, donations unreceipted. And now here is Queen's TV. QPTV is going to have another lottery. And so they sent me this paper to fill out if I wanted to be included in the lottery. I made it very clear to them, though, that a reminder, caveat, that Glendora has statutory protection by the laws of federal, state, and municipal public access, that she is first come, first served. The law says first come, first serve. The law does not say first come, first serve every 13 weeks. Nobody can actually have Glendora's 7:30 p.m. Tuesday time slot unless she consents. No second come can have it without consent. Yours in truth, Glendora. National Federation of Wildlife. They're out to save the grizzly bear. They're awfully cute. Cute little fella. I think there's another picture in here. Are you a grizzly bear? Are you a grizzly bear? So, there's a check for that one. Next one is also the National Federation of Wildlife. The perfect gift ideas for your children. $1.50 to wash. And I like Maytag machines, Maytag. And I like top loaders. I like top loaders. If you get something, you can put it in after its wash starts. And if you don't want something to spin dry and you want to drip dry it, you can take it out before the spin dry.
That's right.
And now where to? We're going to hand in the plates. 175 TVC stands for TV Company. We're going to hand in the plates. Take the 1980 off the road. Keep it running, of course. And part of the museum, and save $250 a year. No, every 6 months insurance. What a rip-off, that insurance. Oh, that was one of the worst lobbies. The insurance companies get together with their greedy dollar signs in their eyes and pummel the public.
Yeah.
What a rip-off. So we have to go to the Department of Motor Vehicles, hand in the license plates, get a receipt. And call up the insurance company, Geico, and tell them. What a ripoff. What a racket. Amos. Just like the days of Amos. Man said, nice hat. You need it today. She wouldn't make me a copy. I forgot to make a copy on my copy machine, and she wouldn't make me a copy. She had a copy machine there that we, the citizens, people of New York, paid for, and she wouldn't make me a copy. They have no heart, these people. Well, how could they have a heart and do all the things they do all day? You notice the emphasis on cashier? All three windows were cashier 1 and cashier 3. Harbinger of winter. Folks, and they wouldn't even make a copy. What would they charge for the copy? $2 or $3. This is storm has been called by some a nor'easter. That means it came in from Canada. Just dumb to Parker. Tow truck right in front of the bank door, so that Franklin will have to go out into the rain. There's a poor earthworm out there in the concrete, rained out of his home, right where people would step on him. We saw Jan and David Bushy from the church. Franklin deposited his checks. So, 1:17 p.m. Walmart. On a rainy, rainy day. The good weather's behind us, the bad weather's in front of us. So the groceries were $88, and a woman in a black blouse, looked more like a jacket, and black pants, and dark glasses, came at me perpendicularly with her shopping cart and said, "How is your show going?" It was Terry Travis, who has fought brilliantly for the custody of her granddaughter. Both she and her son. And Bryant put it out of court. And Bryant told them, Terry and her son, to get out of his court. And he really can't do that. It's the people's court.
Ryan and White Plains?
Yes. He dismissed their case. He got a guardian. They got a guardian disbarred. They sued the Jewish Community Center for the fraud in their psychological testing. And she's going after the license of Joan Cooney, the family court judge. And Tolbert, fighting this terrible battle. She lives in Cortland. And 2 state troopers came to her door and said she was making phone calls over to a place where they were dealing in drugs. And she hadn't done any such thing. And so the troopers lost the case. And they lost the case in town court. Yeah. And what did the judge say to the dentist, Franklin? What did the judge say to the dentist? You swear to pull the tooth, the whole tooth, and nothing but the tooth. There's 3. I bought Franklin a pair of navy blue pants, having no idea what his size is.
What size are they?
Depot. So here's the tape, folks, from the ripoff Gestapo DMV, Department of Motor Vehicles, State of New York. I told the line was about 6 people in line when I came in and 6 people in line when I left. And I told the woman behind. We saved $204 this month by taking the 1980 off the road and handing in the plates in this Gestapo imperialistic country that we have. Or we have a good country, but ruined by these people. That was the insurance industry, and they went up there and paid off the legislators and got this through, this compulsory insurance. And we've never used it, folks. We never used it. Once we used it in Buffalo way back in 1959 or so on a cracked windshield. That on the 1956 Dodge. The windshield was a stress crack. A piece of dirt got down and then eventually caused a crack in the windshield that grew very, very slowly. And that's the only time we ever made a claim, all these years of paying it. Now how much money is that? If we were paying 500, we were paying $1,000 a year, and we've been married 47 years. And maybe it wasn't 1,000. So how much is that? We'll say 1,000 a year for 27 years. That's $2,700. That's $2,700. No, it's $27,000. And then maybe half of that for the rest of our married life. So what's that come down to? About $35,000 we paid out in an insurance. And of course the insurance companies are delighted. But this is how you get hurt in a manipulated government. Is that right, Penny? In-mail was heavy. Remember, we just got rid of the in-mail of October 9th, and now we got the in-mail of October 16th. Tapes returned, and then those over there. So we saved $400 a year. And then we had to pay $1 to hand in the plates. Is that a rip-off, or isn't it? How the plants enjoy this sunshine. And the warmth, how they enjoy the warmth. Poor plants are on the north side, they never get sun. What will happen to them folks? Will they be all right? They never get sunshine. They get daylight. And after that miserable rain yesterday, today is just as mild and pleasant and friendly as can be. And the sun coming through the window is as hot as summer. Do you like the red, white, and blue couch? We bought a floor lamp for here, right here, don't you think? Franklin's going to assemble it. Do you know anything about assembling a floor lamp? This is an old-fashioned lamp, and it is so heavy. This is the way they used to make lamps, floor lamps. They don't make cats any differently. Isn't that wonderful? Yes, that lamp comes in that little box, including the shade. That is so clever. I'll turn it on for you. And the Boston rocker. Buffalo bisons. Won't it be nice when these are painted red, white, and blue? This is the Christmas pillow. That's Katie, and that's Penny. And there's little mice all around. See the little mice? There's a little mouse. They sent the bill to the wrong address. They had the right box number, but they had the wrong city. And it took 10 days for it to be forwarded to the right address. And so we get the bill 10 days late, and we pay it. And in the meantime, they've turned off the service.
Ma'am?
I'm videotaping this. Go ahead, because I'm going to put it on my TV program too. There's nobody as bad as MCI. Go ahead. What do you want to do?
Ma'am, I do not give you permission to tape this.
You don't have to have my permission.
Ma'am, I do not give you permission to tape this.
Well, go ahead. So you don't give it. It doesn't make a hill of beans anyhow. You're being videotaped. What do you want to say?
Okay, ma'am, I'm trying to help you. If we can't get a payment tonight, it's in the mail. So what you have to do is wait until it gets to us and it'll be unblocked, or talk to our customer financial service department. They can go ahead and help you out with an arrangement for the block. I have certain requirements here in my department.
Yeah, you keep your requirements, and tomorrow I get Verizon, and tomorrow I sue you. Okay, it's easy enough.
Is there anything else I can assist you with, ma'am?
You haven't assisted me with anything. What do you say anything else for?
There is a past due balance. I've tried to help you.
There is not a past due balance. Number one, there never would have been a balance past due if you had the sense enough to use the right address. Now, you made the mistake, I did not.
And that's what we're trying to fix, ma'am.
Yeah, we'll fix it. Okay? You've taken away my free speech. You've taken away my telephone. You've caused us stress. You've caused us time. You've caused us energy. You've caused us labor. And you're going to be sued for that. And you'd better come up with a volunteer retribution for the damages that you've caused us.
You need to talk to our customer financial service department. They're the ones that placed the block.
That's where I started.
And
I started with them.
And they're the ones that can resolve the issue for you.
No, Kyle told me in Canada that you would resolve the issue.
We can't with that past due balance.
There is no past due balance. Number one, there's no past due balance. You made the bill 15 days late by using the wrong address. And the White Plains Post Office is mad at you too. And they think you're dumb. Sending it to Block 69, White Plains. And finally you corrected it. We got another bill today. How can you turn off the service when you send us another bill?
Okay, ma'am, here's the...
We got a bill today with the correct address on it. That's when you have to time it as to when it's paid, but it's been paid anyway.
Ma'am, I can't resolve the issue.
I'm not giving you 2 payments. You're so dumb that you would mix that up and we'd never see the second payment again.
It's 3 times I'm placing on hold to get my manager on the line. Please hold.
You should have heard the fight Miss Hill put up just to get a supervisor on the line.
Afternoon, Miss Buell.
Yes, this is Mrs. Buell.
This is Mr. Kruger. I am a supervisor in the block department. How can I help you?
How do you spell your name, Mr. Cougar?
K-R-U-G-E-R.
Okay, what town are you in? What's your address?
I don't give my address out. We're
I
in
see.
New York.
I don't wonder you don't, because everybody's after you.
Ma'am, let's stick to the issue.
The issue is that everybody's after you, because you make people so mad.
Ma'am?
Now, ma'am, here's what you did, Mr. Kruger. Okay? You sent the bill to the wrong address, and it's 10 days late getting to us, forwarded by the White Plains Post Office. And when we get the bill, we pay it. And then you, in the meantime, go ahead and turn off our service. Well, I'm suing you, Mr. Kruger, and I'm suing MCI and the CEO and the corporation, and I'm going back to Verizon.
Okay, ma'am. Hello?
What are you saying hello for? I think we're beyond that point.
Well, I thought you hung up. What you need to do is speak to the finance department. This department will not remove that block for you because you have a past due balance.
I do not have a past due balance, okay? I paid it when we got it.
Ma'am?
What you have is a wrong address, and you can't call it a past due balance, you blockhead. And you're being videotaped, and it's going on my TV show. MCI stinks, folks. Do not use MCI. And this is the second time you've done it. And you owe me considerable damages for the stress, for the labor, for the energy,
Ma'am, are you
and for the
finished?
inconvenience, and for my freedom of speech.
Okay, are you finished, ma'am?
Finished what?
Unless you want to pay this past due balance.
I have paid it, you blockhead! It was paid Sunday! He hung up, folks. Okay. That's MCI. Whatever you do, don't use MCI. Go to another long-distance carrier.
If you'd like to make a call, please hang up and try again. If you need help, hang up and then dial your operator.
See, that shows you that he hung up, folks.
If you'd like to make a call, please hang up and try again.
Okay.
If you need help,
I can't
hang
call.
up and then
Let me
dial
show you
your
what
operator.
happens. Let me show you what they did. Let me show you now. All right, I'm going to dial a number. 1-914-949-9495. Now watch. This is what they did.
We are unable to complete your call.
See that? They
Please
blocked everything.
customer service number written
That's
on your
local,
statement for
that's
assistance.
regional, and that's long distance.
BT. We
Don't
are unable
ever,
to complete your call.
don't
Please call
ever
customer
put your
service
faith,
number written on your billing.
don't ever put your faith in MCI. Look what they did to us. Words?
You call 9495.
Do they give you credit for all of the money that you have sent them? Thousands and thousands and thousands of dollars?
For money.
For years we've used MCI. We have 3 lines with them, 3 accounts. Thousands and thousands and thousands of dollars Franklin has paid them. And look what they do. They're stupid enough to send the bill to the wrong address. It takes 10 days to forward it. And then they turn off the service. Do not use MCI. Absolutely never use MCI. Take another long-distance carrier. So, Mr. Kruger asks, what can he do for us? 1, you can listen when people give you an address and send your bills to the right address. And when you don't get payment, you're in the communications business and you have a telephone business and you can call people up and you can say, we haven't received the payment. Let's discuss this. And then we will tell you, what address did you send it to? Well, we haven't received the bill. And we're not paying a bill until we receive it. So you wake up and you send the bill to the right address. And you also take care of your own accounting practices. I believe MCI is under investigation for these accounting practices. They're aggressive accounting, so-called. But worse than that, they didn't report the losses that they had. Well, they got another loss tonight. The bill was paid Sunday, and they don't even take into account the fact that the post office was closed Monday, Columbus Day, fake Columbus Day. No honoring of Columbus, just taking Monday off because it's more convenient. So MCI doesn't even take into account that the post office was closed Monday. And they go and shut off the service. The service was shut off sometime this afternoon because I made calls this morning. And here it is, only Thursday. And they don't have a local office the way that they should. The bills go halfway around the globe.
Yeah, that's right.
And they don't even allow for that. MCI is a bunch of idiots. Do not use MCI. Hill, Kruger, Phillips have to be pretty dumb not to resolve that here and now. Well, they will find out. So, we sue MCI, the CEO, whoever it is. Roberts has departed involuntarily. We'll sue the company, and we'll sue Hill, Phillips, and Kruger. See if we can straighten them out. I don't want that company anymore, folks. I don't want them anymore. What's wrong with them? They won't even take into account the thousands and thousands and thousands and thousands and thousands of dollars that Franklin has paid them. I think we've been an MCI customer since... Wait a second. Way back in Buffalo. Since 1983. And we praised and hailed and hurrahed Mr. McCowan because he broke the AT&T monopoly. And he sacrificed his life to do it. He died at an early age of a heart attack. But he broke the AT&T monopoly. Judge Green wrote the decision. And so we hailed McGowan as a hero and patronized MCI every way that we could to get rid of AT&T and New York Tel. Look what they turned into. How a good thing has been turned bad. This isn't the second time, folks. This is the third time. They lost checks. One check was for $216. They lost that. They lost so many checks that they were giving Franklin credit for $300. And I think one bill was 1 cent, wasn't it? Or 2 cents?
Yeah,
Wasn't it?
I
You had to send them a check for 2 cents. Oh, boy, do they mess things up. This is MCI. Do not use MCI. Do not use MCI. Outrageous. So I was going to tell you before all this happened with these idiots, MCI, WorldCom, I was going to tell you about poor Franklin. He lost his wedding ring. He's very upset. He lost it yesterday. And he thinks he saw it when we were at the health food store having a salubrious bowl of chili, vegetarian chili. And it was a chilly night, too. It was all that rain. Oh, it was an awful night. And then we gave a very nice set of lavender sheets, a contour and a flat sheet, to the Upton Lake Christian School. They have a clothes bin down at the Gulf Station, and we very often put clothes in there. So we wanted people to have the benefit of this nice bedding set. And Franklin thinks maybe in putting that into the bag, the plastic bag, to put it into the clothes bin and stuffing it down in, that his ring might have fallen off. And we called them, and Barbara was sympathetic right away when he said he thought he'd lost it that way. She said, oh no. So she said she'd try to see if it could be traced. So he's very upset because he's had the ring a long time, for 47 years, his wedding ring. Franklin is collating the first 24 pages of the appellant's brief to the United States Court of Appeals for the Fourth Circuit, Richmond, Virginia, on Glendora versus Walker and Hogan and quite a few people, de Blasio and Swirsky, New York State Commission on Judicial Conduct, the New York City Department of Finance and its Parking Violations Bureau, Karen Murphy, the County Clerk of Nassau, and also the head of the clerkship of the courts, the Nassau Supreme Court, so-called, the Nassau Criminal Court. I hope there's time to read you that paper. There's so much there that you should know. It takes all day when you come back from errands to go through the mail, open it, and to put things away, and to put the expenses into the book.